Hello students, welcome to the lecture on civil liberties. After this lecture, you will be able to learn the following objectives. Explain the civil liberties. Explain the Bill of Rights and 14th Amendment. Describe freedom of religion. Explain the freedom of speech and press. Describe the defendants' rights. Okay, so first of all, what is a civil liberty? Think of it as your protection from the government. This is the law that tells a government that they cannot mess up with. Also, think about these as your personal freedoms. Civil liberties are the rights and protections a society guarantees to everyone. These are certain rights given to the people under the First Amendment to the Constitution, which includes freedom of speech, expression, press, assemble and worship, right to vote, right to equality in public places without any interference or restriction from the government. They are given to treat all the people equally under the law and make them enjoy rights of speech, protection, enjoyment and liberty. Let us now hear more on how the civil liberties are intertwined with the civil rights.
Well, civil rights are not quite the same thing as civil liberties. Civil rights tend to refer to kind of public rights like the right to vote, the right to be treated fairly by the government. They're not sort of individual liberties that one has against. They're more in terms of groups of people who claim to be discriminated against. Civil liberties gets connected with civil rights because in the 1960s, in order to fight the civil rights movement, Southern states began passing laws restricting the operations of these organizations like the NAACP, the Southern Christian Leadership Congress of Martin Luther King. They would pass laws requiring these organizations to submit membership lists, and that would open the door to, persecution of people who were members. They began putting people on trial for criticizing public officials and things like that. These were meant to suppress the civil rights movement. They weren't a wholesale attack on civil liberties, but they were meant to prevent these civil rights organizations from functioning. And the Supreme Court was forced to defend the right of these organizations to exist and to carry on their operations, and in doing so, again, expands the definition of civil liberties. You can criticize a government official without fearing persecution. You can operate as an organization without the government knowing every member of your organization. And that, of course, applies to other groups, not just civil rights organizations.
The Bill of Rights and 14th Amendment. The overwhelming majority of court decisions that define American civil liberties are based on the Bill of Rights added to the Constitution in 1791. Civil liberties protected in the Bill of Rights may be divided into two broad areas: freedoms and rights guaranteed in the First Amendment, religion, speech, press, assembly, and petition, and liberties and rights associated with crime and due process. This video here will give you a better understanding of the Bill of Rights.
The first 10 amendments to the U.S. Constitution, also known as the Bill of Rights, were ratified or passed over 200 years ago. But even though they're a bit, old, these first 10 amendments are still the most debated and discussed section of our Constitution today. So can you remember what they are? Let's take a look. The First Amendment is the freedom of speech, press, religion, assembly, and petition. This may be the most revered of the amendments. The First Amendment protects our rights to say and write our opinions, worship how we please, assemble together peacefully, and petition our government if we feel the need. The Second Amendment is the right to bear arms. The original intent of the Second Amendment was to protect colonists from the invading British soldiers, but it now guarantees that you have the right to own a gun to defend yourself and your property. The Third Amendment is called the Quartering Amendment. It was written in response to the British occupation and as a result of the colonists having to house or quarter soldiers in their homes during the American Revolution. Because of this amendment, our government can never force us to house soldiers in our home. The Fourth Amendment is the right to search and seizure. The police can't come into our home without a search warrant and take our personal property. Today, many concerns have arisen about our rights to privacy and technology. For example, can the government track your location with your smartphone, or can social media postings such as on Facebook and Twitter be used without a warrant? On to the fifth. It's all about due process. You've probably heard the phrase, "I plead the Fifth," in movies or on TV. They're talking about the Fifth Amendment, which says that you don't have to take the witness stand against yourself if you may end up incriminating yourself. Okay, we're halfway done. The Sixth and Seventh Amendments are about how the legal system works. If you're accused of a crime, you have the right to a speedy public trial and an impartial jury. You also have the right to a lawyer and the right to take the stand if you choose. This is important because it will prevent the accused from sitting in prison forever and insists that the prosecution proceed with undue delay. The Seventh says that if you're charged with a crime, you have the right to a jury trial where 12 impartial peers decide your innocence or guilt in the courtroom as opposed to a judge doing it all alone. The Eighth Amendment prohibits cruel and unusual punishment. Is the death penalty cruel? Is it unusual? It's hard for Americans to agree on the definitions of cruel and unusual. The Ninth and Tenth Amendments are called the non-rights amendments. They say that the rights not listed in the Bill of Rights are retained by the
Civil rights are also protected by the 14th Amendment, which protects violation of rights and liberties by the state governments. The 14th Amendment was adopted on July 9, 1868. This amendment was part of the Reconstruction Amendments, which helped the reconstruction of the American struggle after the Civil War. The 14th Amendment defines national citizenship and forbids the states to restrict the basic rights of citizens for any other persons. This amendment existed to protect freed slaves' rights being denied by all states. Under the 14th Amendment, there are three clauses: the Citizenship Clause, the Due Process Clause, and the Equal Protection Clause. The Citizenship Clause, also referred as the Naturalization Clause, declared that the African Americans were not and could not become citizens of the United States or enjoy any of the privileges and protections of citizenship. The Due Process Clause prohibits state and local governments from depriving persons of life, liberty, or property without the sanction of law. The Equal Protection Clause requires each state to provide equal protection under the law to all people. Section 1. All persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial offices of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States, or in any way abridged except for participation in rebellion or other crime. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3. No person shall be a senator or representative in Congress or elector of President and Vice President or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Section 4. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for service in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations and claims shall be held illegal and void. Section 5. The Congress shall have power to enforce by appropriate legislation. Protection of civil liberties and civil rights is basic to American political values, but the process is far from easy protecting. But the process is far from easy. Protecting one person's right may involve violating those of another. How far should the government go to take positive action to protect minorities? The answers often come from individuals who brush most closely with the law, whose cases help to continually redefine American civil liberties and rights. Now this video here will help us shed some light on the 14th Amendment.
The 14th Amendment was adopted on July 9, 1868. This amendment was part of the Reconstruction Amendments, which helped the reconstruction of the American South after the Civil War. The 14th Amendment defines national citizenship and forbids the states to restrict the basic rights of citizens or any other persons. This amendment existed to protect freed slaves' rights from being denied by all states, especially Southern ones. Under the 14th Amendment, there are 3 clauses: the Citizenship Clause, the Due Process Clause, and the Equal Protection Clause. The Citizenship Clause, also referred to as the Naturalization Clause, represented the reversal of Congress's decision on the Dred Scott v. Sanford case, which declared that African Americans were not and could not become citizens of the United States or enjoy any of the privileges and protections of citizenship. The Due Process Clause prohibits state and local governments from depriving persons of life, liberty, or property without certain steps to make it fair. The Equal Protection Clause requires each state to provide equal protection under the law to all people. Many court cases have occurred because of the 14th Amendment. Among them include the famous court case Brown v. Board of Education of Topeka in 1954, which was based off of the Equal Protection Clause. This case later dismantled racial segregation in the United States. There are many cases involving the Due Process Clause, such as Luckner v. New York and Adkins v. Children's Hospital. These cases struck down on maximum hours for workers and the minimum wage. Although there has been a multitude of court cases surrounding the topics of the 14th Amendment, it protected the rights of African Americans and continuously forbids the states from restricting our basic rights. This amendment helps our government comply with all men are created equal.
Okay, so what is freedom of religion? You can practice any religion or not practice a religion. Now, the important thing to know the background of this question, that many people came to the United States in the beginning because they were not experiencing religious freedom where they lived. Because of that, they came to the colonies or the United States. So the founding fathers wanted to make sure that they would protect the privacy, whether to practice a religion or not practice a religion at all. The First Amendment of the United States Constitution protects the right to freedom of religion from government interference. The United States Constitution addresses the issue of religion in two places, in the First Amendment and the Article 6 prohibition on religious tests as a condition for holding public office. The First Amendment prohibits the federal government from making a law respecting an establishment of religion or prohibiting the free exercise thereof. This provision was later explained to state and local governments through the incorporation of the 14th Amendment. The video here will give an insight into the views of freedom of religion in America.
Now, one area in which the court has been quite active and has upset many Americans is with prayer in schools. In 1962, it struck down a New York state law that required every school day in public schools to start with a non-denominational prayer. In 1963, it struck down a Pennsylvania law that required the reading of selected Bible verses and the recitation of the Lord's Prayer every day in public schools. These decisions were met with a political outcry. Constitutional amendments to overturn them were introduced in Congress, and public opinion registered enormous opposition to these opinions. Now, these constitutional amendments did not pass the Congress, but public opinion has stayed resolutely opposed to the court decisions and in favor of prayer in schools. Nonetheless, the court has continued along these lines. In 1992, for example, it banned prayer at high school graduations for public schools. And then in the year 2000, it banned prayers at football games, at the start of football games, high school football games, again on the notion that organized prayer was coercive. Then again, you might recall there was always President Reagan's comment that as long as there will be exams in school, there will be prayers in school. Another area where the courts have been involved in school deals with curriculum. And here the question is, how much religious content can you teach in school? In 1968, for example, Tennessee had prohibited the teaching of the theory of evolution. The court struck that down. In 1987, Louisiana had tried something different. It said, you can teach evolutionism, that's fine, but you have to teach creationism with it, the theory of the Bible, of the Christian Bible, of the Old Christian and Jewish Bible, of the Old Testament. The court struck that down as well, saying it violated the Lemon Test. There was no secular purpose here. Now, I don't want you to take away from this the notion that schools are deeply hostile to religion. There's lots of room in schools for religious belief and religious groups. Religious groups, like any other groups, have access to schools. They can use school classrooms, they can use them after hours, given whatever requirements the school has for any other group. Clearly, students can gather informally to pray, to read religious texts, and the like, and when appropriate, students can write about their religious feelings, spiritualism, and so forth. Now remember, there's also that other clause, the free exercise clause. Remember, Congress shall not interfere with the free exercise of religion. The question is, when does state action so interfere? Now, you might think this is easy, but it gets complicated fast. And the way the court has tried to deal with this is through a distinction between belief and action. Now, this is a tough one to make, because sometimes one's belief requires action. Some of these cases illustrate it. The case that announced it was an 1878 case that had to deal with Mormons in Utah. Part of the belief of Mormons is the practice of polygamy. That is to say, one man having more than one wife at the same time. What the court said is that Congress can indeed ban that practice. Can't tell Mormons what to believe, but it can ban a practice that is banned for everyone else without interfering with the free exercise of their religion. Another example comes from schools. The Amish people do not want their children to go to school through high school. They say that if you make them go to school through high school, they will drift away from the community. They agreed to let them learn how to read and to do math and to write, but they wanted to remove their children from the schools after the 8th grade. Wisconsin, it turned out, had a law that required students to go to school until they were 16. Many states have similar laws. The court here struck down the law. It said the Amish did have a right to the free exercise of their religion, and it could remove their children, or they could remove their children from schools after 8th grade. Yet another case had to do with an Orthodox Jew in the Air Force who was a clinical psychologist. His belief required him to act, to wear a yarmulke, the small head covering that Orthodox Jews wear. He was disciplined by the Air Force for this because it violated Air Force regulations. Now, it turns out that Congress overturned that by legislation. Perhaps the most noticeable or noteworthy decision here comes from 1990 from Oregon. It's a decision called Oregon v. Smith. And the plaintiff here, the person who brought the suit, Smith, was a Native American who took part in a Native American religious ceremony which included use of the hallucinogenic drug peyote. He lost his job because of this. The use of hallucinogenic drugs violates Oregon law, and he claimed this violated his right to free exercise. Now, the U.S. Supreme Court said no, it didn't. This was the belief-action distinction. He could believe what he wanted, but if he took the drug, that violates the law. Congress tried to overturn that decision in a piece of legislation called the Religious Freedom Restoration Act in 1993. What the Congress said is when a claim of free exercise is being made, the legislation adopted must be the least restrictive means of reaching a compelling governmental objective. It may be a compelling objective to prevent people from using hallucinogenic drugs, but in this case, Congress felt there were other means of achieving it. However, the court overturned that piece of legislation recently, arguing that the Congress has no power under the separation of powers to tell it, the court, how to make its decisions. Now think again about the wall here between church and state. Clearly, we believe in a separation of church and state. The United States of America is not to be a theocracy. On the other hand, there are many Americans who hold deeply religious views. And the tension and the challenge we face is how to respect their views without coercing those who have other views in the process. That is one of the challenges this country faces in the 21st century.
Freedom of speech and press. In the area of freedom of speech, the courts have faced a similar problem. Where does the state draw the line between a person's right to speak and the rights of others that may be affected by that speech? The degree of protection afforded a speech largely depends on its types. In general, the courts have held that political, public, and symbolic speeches are protected unless such speech presents a very clear and very present danger. Let us talk about the significance of free speech. Without free speech, no search for truth is possible. Without free speech, no discovery of truth is useful. Charles Bradlaugh. Freedom of speech is the most sacred in American democracy. Prior to the Revolutionary War, the English Bill of Rights provided some basic rights, but they did not permit freedom of speech, a restriction that many colonial Americans resented. After the Revolutionary War, the framers of the Constitution placed special emphasis on guaranteeing liberty and individual rights for all citizens. The framers of the Constitution were very clear when they were addressing freedom of speech. Their intention was to allow citizens to express their ideas and opinions without fear of retaliation, especially when discussing the government. Congress shall make no law abridging the freedom of speech. First Amendment, ratified 1791. The concept of freedom of speech has been constantly challenged, re-evaluated, and redefined since the Constitution was first created. The country and the culture have evolved beyond what the framers could have envisioned, and the Supreme Court has repeatedly ruled on what is free speech. Free speech is classified in two ways: pure speech and speech plus. Pure speech is any direct form of written or oral communication targeted towards a specific individual or group. It includes face-to-face communication, broadcast speech, or written publications. Speech plus may involve direct communication, but also includes expressive conduct. Expressive conduct must involve an action such as distributing pamphlets, picketing, or participating in a public protest. Since speech plus incorporates actions in addition to spoken or written communication, it is much more difficult to label it as acceptable or unacceptable. Another example of speech plus is symbolic behavior, a broad designation that includes activities such as civil disobedience. Burning a US flag or an effigy are some of the best known examples of symbolic behavior. Interpreting symbolic behavior is challenging as it is often difficult to separate speech elements from behavioral elements. The foundation of the United States includes key acts of symbolic speech and expressive conduct. The Boston Tea Party, for example, enlightens our country's history. Courts today almost always support freedom of speech unless criminal or potentially dangerous elements are involved. Now we shall talk about the rights and limitations of free speech. Americans have been skeptical of eliminating First Amendment rights, challenging limitations on free speech at every opportunity. The Supreme Court has been equally reluctant, limiting speech only when it proves to be slanderous, egregious, a threat to public safety, or a national security risk. Freedom of speech is most often called into question when words are used to encourage or promote unlawful actions. The Supreme Court developed the clear and present danger test, Schenck versus the United States, in 1919, ruling that the government may prohibit speech that creates an immediate threat of criminal action. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. It does not even protect a man from an injunction against uttering words that may have all the effect of force. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that Congress has a right to prevent. It is a question of proximity and degree. Oliver Wendell Holmes, 1919, In 1925, the court established the dangerous tendency test that attempts to measure the likelihood of violence or danger resulting from questionable speech. In Gitlow versus New York, 1925, the Supreme Court upheld Gitlow's conviction for distributing socialist propaganda that supported the violent overthrow of the government. Though most forms of symbolic speech are protected, there are limitations. For instance, the government can regulate speeches in a public forum or special facility. Other limits on free speech involve obscenity, defamation, and speech leading to unlawful actions. The protection of commercial speech or advertising can be limited as well. The government can prohibit false advertising, prevent the marketing of illegal products or services, and in some cases even regulate legal products. In 1986, the Supreme Court ruled that the government could restrict advertisements for outlawed products, a ruling that has since been used to restrict the marketing of alcohol and tobacco products. The court has also defended controversial commercial speech. In 1999, the FCC banned New Orleans radio stations from airing advertisements for legal casinos in Mississippi, arguing that they promoted immoral behavior. In Greater New Orleans Broadcasting Association versus United States, the court ruled that since the ban on casino advertising would have no effect on limiting the hazards of gambling, it violated the First Amendment. One of the most commonly regulated uses of speech is fighting words, words that inflict injury or tend to incite an immediate breach of the peace. In Chaplinsky versus State of New Hampshire, the Supreme Court upheld Chaplinsky's conviction for calling a city marshal disparaging names. The court argued that fighting words do not convey ideas and are therefore not protected by the First Amendment. Later, the Supreme Court upheld the use of fighting words. Arrested in 1970 for wearing a jacket with an offensive political message written on it, Paul Cohen was convicted under a California statute prohibiting the malicious and willful disturbance of the peace. Yet, the Supreme Court set a precedent by overturning the convictions. Since the expletive was not directed at anyone or intended to provoke group action, the court ruled it protected speech. The Cohen case immediately changed the perception of free speech and has since broadened the scope of acceptable speech. An extension of freedom of speech is peaceful assembly. The First Amendment allows citizens to speak, protest, or picket on public property as long as they do not disturb the peace or violate the law. Dirk de Jong, a proponent of criminal syndicalism, the advocating of violence or sabotage, tested this protection in 1934. After his arrest, de Jong filed an appeal contending that there was insufficient evidence to warrant his conviction and that his right to free speech had been violated. The Supreme Court agreed, overturning his conviction in 1937 and setting a precedent for future discussions about peaceful assembly. Despite the significance of the de Jong ruling, the court has limited free assembly when necessary. In 1941, a group of Jehovah's Witnesses were arrested for parading without a permit while distributing leaflets. The group appealed their conviction, citing their right to peaceful assembly on public property. However, in Cox versus New Hampshire, 1942, the court upheld the conviction, stating that municipalities have the right to ensure the safety and convenience of public streets. Today, freedom of speech remains the most sacred in our nation's history. The First Amendment has been and will always be challenged in new ways. Both the American public and the Supreme Court continually fight against any limitations to their freedom. Defendants' rights. Since its inception, the United States has been unique in its concern for fairness and justice in the legal process. Every single citizen and legal resident of the US is guaranteed certain rights under the Constitution. Even those accused, charged, or convicted of a criminal offense still retain legal rights. In the event that these rights are violated at any point in the proceedings, from the arrest to the trial, the outcome of a criminal case can and usually will change, often in favor of the defendant. Individuals who have been accused or charged with a crime have various legal rights, 5 of which are extremely important and should always be invoked. They include defendant's right to an attorney. Every defendant has the right to obtain legal counsel. If an individual cannot afford an attorney, the court must appoint one at no cost. A defendant can also choose to represent him or herself in court, which is not recommended. Defendant's right to a jury trial. All individuals charged with crimes have the right to a fair, public, and speedy trial. Furthermore, they are presumed innocent unless proven guilty beyond a reasonable doubt by 12 impartial jurors. Defendant's right against self-incrimination. A defendant has the legal right to remain silent to prevent self-incrimination. Defendants are also legally eligible to testify on their own behalf. Defendants' rights to confront witnesses. An individual has the right to question and cross-examine every witness that testifies against him or her in trial. Defendant's right to produce evidence. A defendant may present his or her evidence to the court or file a motion requesting a subpoena to call forth all witnesses and evidence that could favorably determine the outcome of the case at no cost. Now, this video here will tell us more on the rights of defendants.
When the Bill of Rights was added to the Constitution, it didn't have much about people's inherent rights, but had an awful lot about their rights in court. This is the bulk of Amendments 4 through 8, which, if you do the math, is half of the first 10 amendments. The actual process that defendants go through is pretty much protected at every level, since people before the Constitution could interfere anywhere with the process. First, a crime is committed. Let's say this guy, Al, steals some bread, and then he is caught and arrested. However, due to the protection of habeas corpus in the first article of the Constitution, the police need a probable cause for arrest before they do so. Once they jump over that hurdle and get a legitimate reason, they need a warrant to search his house for the stolen bread, since unreasonable searches and seizures are protected against in the Fourth Amendment. After they obtain the warrant and search his house, the police may find another offense, like a gigantic opium den, but they can't arrest Al for that until they get a separate warrant to search for opium den as well, unless the opium is made from the stolen bread. Finally, police find the bread and make the arrest, and are required to read Al his defendant's rights, since Miranda v. Arizona in 1966 proves that most Americans don't know as much about their rights as you do, since they haven't watched this video. Then, after telling Al that he has the right of counsel, and will be given a lawyer if he can't afford one, he finally gets taken to jail. At the trial, the prosecuting judge is forbidden from using any evidence obtained illegally as evidence in court. Were this trial taking place before 1961, this wouldn't be an issue, since the exclusionary rule wasn't incorporated to the states until Mapp v. Ohio declared that the government can't use their marijuana plants to claim that you don't gamble. Al, as the convict, also can't be used as a witness against his own case due to the protections of the Fifth Amendment. Such questioning has become so common that now the phrase, "I plead the Fifth," has joined the American lexicon, somewhere between "I was only going 50" and "I'm telling you I'm not drunk." After the court case, the required jury of peers gets to make a statement as to whether he's guilty or not, resulting in a ruling by the judge on Al's punishment. Under the protections of the Eighth Amendment, no sentence can be cruel and unusual punishment. Of all the parts of defendants' rights, this has garnered the most criticism and argument, since what one person considers to be cruel and unusual may not be for another person. The largest argument here is, of course, the death penalty, since death is the harshest punishment that can be given to a person. This issue has come up again and again in the courts, and the Supreme Court currently states that capital punishment is an extreme sanction suitable to the most extreme of crimes. The only definitive ruling on the death penalty is that it can't be the mandatory penalty for a crime, with the possible exception of shooting the president, since all 4 presidential assassins were killed for their actions. Luckily, though, Al has only stolen a loaf of bread, so his punishment will most likely only be some menial work and service. Unless he shot the president.
Summary. Now in the end, let us summarize what we have learnt in this lecture. Civil liberties are certain rights given to the people under the First Amendment to the Constitution, which includes freedom of speech and press, expression, assemble in public places without any interference or restriction from the government. Civil liberties protected in the Bill of Rights may be divided into 2 broad areas: freedoms and rights guaranteed in the First Amendment, and liberties and rights associated with crime and due process. Civil rights are also protected by the 14th Amendment. Individuals who have been accused or charged with crime have 5 important legal rights: defendant's right to an attorney, defendant's right to a jury trial, defendant's right against self-incrimination, defendant's right to confront witnesses, defendant's right to produce evidence.